미국의 코로나 사태가 백신 접종의 시작으로 다소 진정될 것으로 기대되고 있습니다. 그런데 경제 활동이 활발해지면서 교통량도 늘고 교통사고도 다시 증가하고 있는 추세 같습니다. 교통사고를 당했을 때 어떻게 대처를 해야 할 것이고 어떤 보상을 받아낼 수 있을지를 노승훈 변호사로부터 들어보겠습니다. 최근에 이제 코로나 사태로 좀 줄었던 교통량이 다시 늘어나서 또 이제 결과적으로는 또 이제 교통사고도 많이 늘어나는 것 같습니다. 교통사고를 당했을 때 어떻게 대처하는 것이 가장 현명하다고 생각하십니까?
With the severity of the injuries that we were seeing in our office, the other problem because of COVID was that nobody wanted to get treatment. Everyone was afraid of going to the hospitals, of going to the doctor's offices, and nobody wanted to have personal contact, which made it extremely difficult for us to represent their injuries and the extent of the treatment that they required. So the cases have become a lot more difficult. Adding on to that difficulty, the insurance companies were understaffed. Also adding on to the difficulty, the courts were closed. So a lot of the cases that we have going, even though we file lawsuits, the court cases aren't being scheduled until 2 years later, 2022. Now, everything about a personal injury case has been made more difficult. A good case always involves good information, good medical services, good treatment, and rehabilitation. And if our clients can't get that, it becomes difficult to prove that case come settlement or court. And again, if we don't have the good information to go to court with, it makes our trials and our court cases that much more difficult. So COVID really has turned this personal injury practice into something different, and it's for clients, for the Korean community, it's made it that much more important that they seek very experienced law firms and lawyers, such as our firm, to really handle their case properly.
예, 우리 한인들도 상당한 그 어려움을 겪을 수도 있는 것 같은데요. 노승훈 변호사께서는 과연 이런 그 교통사고에 대해서 조금 구체적으로 어떻게 지금 다루고 계신지를 한번 소개를 해주시죠.
The attitude isn't different. Procedure-wise, it has become extremely different because now we have to prepare cases to get the same information we would normally get, but from clients who don't want to go to the treatment provider. So getting the medical reports from the emergency room, the initial doctor evaluation has become extremely, extremely important. Only in those records and only in the ongoing treatment are we going to be able to prove that the client had a certain type of injury and was not able to treat because of COVID or because of fear or of health concerns. That has to be specifically documented in a way that a judge would understand, a jury would understand, and subsequently that an insurance adjuster will understand. If that's not documented properly by experienced attorneys, 1 year later, 2 years later, all it looks like is someone got hurt, there was an injury, and the injury must not have been serious enough because the person never went to treatment. There's also follow-up evaluations that must be done that a lot of other cases that we see are missing. We even have a lot of clients who 6 months, 8 months, 2 years later try to come to our firm and try to leave their current representation because they're not happy with how the case is going. And unfortunately, we can't take those cases because it's 1 year, it's 8 months of missing records. It's 1 year and 8 months of missing notes. So preparing the case for litigation is the only way to preserve your interest in a case and to really document your injuries so that you can get proper compensation now. Especially because of COVID, it's become that much more important.
구체적으로 메디칼부터 차량 파손 보상, 메디칼, 그 다음에 나중에 또 다른 그 보상까지 순차적으로 받아낼 수가 있지만은 이제 그 우선 급한 것부터 할 수도 있고 법정 변호사를 통하게 되면 아무래도 이제 보험사라든가 거기 좀 행동이 빨라진다는 그런 것으로 이해해도 되겠죠.
So the difference is very easy to tell. When you negotiate with an insurance company, they have a team of lawyers and they have a team of adjusters who are extremely experienced at how to evaluate a case and what their bottom line is going to be for any particular type of injury. Now, even lawyers who don't go to court, even lawyers who don't know the personal injury realm as well as litigation attorneys do, all they do is settle. And they settle for bottom dollar. They never get the value of a case properly because, number one, they don't know the inside of a courtroom. They don't know what needs to be established to get maximum value. And number two, most importantly, the insurance companies already know that they're too afraid to go to court. When even lawyers who don't go to court are treated that bad by insurance companies, what do you think the insurance companies are going to do to just a normal person who's injured in an accident? A normal person who was never able to document their cases properly. A normal person that doesn't know what the value of a particular type of injury is. A normal person that doesn't know how to read medical records and identify when an injury has been properly written down and notated, when treatments have properly been recommended and finished, when certain issues such as permanent damages have not been evaluated, when certain issues such as loss of income have not been properly presented to an insurance company. These are all things that they can use to devalue a claim. Now, as I was mentioning, certain attorneys, even many attorneys who don't go to court, don't know how to properly present a case to insurance companies. So unfortunately, their clients end up losing a lot of money on these things. But most importantly, for an individual who has no knowledge of the law, for them to try to handle their own case and settle with an insurance company is just begging for trouble. There's no way they will get the proper value out of the case. If for anything else, then they know that the person doesn't know what they're doing.
예기치 않게 사고를 당했을 때에는 그야말로 경험 있고 합리적으로 판단하는 전문가와 상의해서 합당한 보상을 받는 게 가장 좋을 듯합니다. 오늘 도움 말씀 고맙습니다.